Hi, everybody. Welcome to the first week of the second part of our course, which, as we've talked about, has four parts. And so we're through the first part as of our class on Tuesday night. And now we're jumping into the second part of the course. And today's class will talk about an overview of the American legal system. And in talking about this overview, I want you to think about the constrained court versus dynamic court view that we discussed at length on Tuesday night. So, as I mentioned, this section of the course marks our transition to part two of the class, and the midterm will take place at the end of part two. So, just to give you a reminder of the timeline. So, as we've discussed at length, this is a class about the role of courts in the American policymaking process. And so, in part one of the course, we discussed the promises of the American courts. So, the first being orderly dispute resolution, and the second being the court's ability to correct political failures. And then we ended the first part of the course the other night applying the constrained court versus dynamic court debate, which again stems from Gerald Rosenberg's 1991 book, The Hollow Hope. And so this debate allows us to sort of think analytically when we describe what the courts look like, so that we're not just, memorizing the structure of the courts, but instead thinking about how the courts are organized with respect to this theory in mind. So now we explore this debate, the CCV versus DCV debate, by looking at the relationship of the courts to the other political branches and levels of government. And this is really sort of putting meat on the bones of the institutional constraints, which the CCV versus DCV talks about. And we do this by talking about the ways in which the courts are organized. And so our goal here is to develop an understanding of how American courts are organized, how they differ from other courts abroad, and when they are constrained. So we'll be talking mostly about internal institutional constraints today, but we'll be touching on external institutional constraints as well. But first, I'd like to talk about the PBS Frontline documentary that we watched in the second part of class on Tuesday night. So, as I mentioned in class, the reason why I wanted to show y'all this movie is not so that you'd have a better understanding of the abortion debate, although, I'm not going to argue that it's not important to understand where the abortion debate stands and sort of how it's gotten there. But instead, I want you to use what was in the documentary to think about this idea of the constrained court versus dynamic court view, and think about how policymakers have attempted to use the courts to further their own policy goals. So on that note, some questions on the film that I'd like for you to think about. So if you think back to the passage or the Roe versus Wade decision, which the Supreme Court heard the case in 1971. They decided the case in 1973. And just like Brown versus Board, scholars of politics and scholars of the American court system often talk about Roe versus Wade as an example of the courts acting in a powerful and effective way. And in this case, they were taking abortion rights, they were nationalizing abortion rights, and they were enshrining a woman's right to get an abortion as national law. But what I think the film illustrates is that if you're thinking about Roe versus Wade in light of the CCV versus DCV debate, then it seems like the subsequent actions that the court took in Planned Parenthood versus Casey and the opportunities that they left open for states to erode abortion rights, if you look at it from that lens, then it seems like perhaps the court was not acting as powerfully as we originally thought. So when you're answering this question, or when you're thinking about this question, think about the sort of last row of the DCV versus CCV debate. And if you recall, one of the ways that we can think about measuring the court's effectiveness is the outcomes that were brought forth as a result of a Supreme Court or judicial decision. And so in this case, yes, Roe did nationalize abortion rights, but like I mentioned, they left open the possibility for states and for lower courts to slowly erode those rights. And then the second major question I have for you is how have pro-life activists used the courts as a policy-making tool since the passage of Roe versus Wade? So as the film talked about, pro-life activists have been really clever about using the courts to slowly chip away at abortion rights. And so you can think then, okay, from that vantage point, the vantage point of hoping that abortion eventually becomes illegal or non-existent through extreme sort of regulatory measures, then it does appear that pro-life activists have effectively used the courts as a policy-making tool. And so, as of now, abortion is still legal nationwide, but as the documentary showed, courts have essentially upheld the constitutionality of state legislation that mandates that abortion clinics adhere to regulatory standards that are pretty tough and that can put them out of business. So again, I just urge you to think about the factors that you're using when you're evaluating whether or not policymakers from the pro-life side of things have been effective at using the courts as a tool. Okay, so on to our overview of the American legal system. So as before, it's important to get some definitions out of the way. And so if we're going to talk about the ways in which the courts are organized and the ways in which the federal and state courts not only overlap with each other, but overlap within sort of the state court realm and within the federal court realm, then let's get some definitions on the table first. So again, the definition of law that we're working from is a body of rules that are enacted by public officials and backed by the force of the state. And stemming from law is this idea of public law. And this is the area of the law that directly involves the government. And so here we're talking about a relationship among governmental entities and relationships between citizens and the state. And stemming from public law is, of course, criminal law, which is a body of public law that aims to prevent harm to society. And so here the law is declaring what conduct is criminal, and it also prescribes punishment for such conduct. On the other hand, we have private law, which governs relationships among private entities. And civil law then stems from private law as a body of private law that is concerned with private rights and private remedies. So as we move forward throughout the class and at the end of part 2, we're going to talk about adjudicating criminal cases in the American court system and adjudicating civil cases in the American court system and think about those in a comparative context. But for now, you can think of these sort of definitions as 3 levels of the law. So level 1, of course, being the law itself, level 2 being the distinction between public and private law, and level 3 being the distinction between criminal law and civil law. So that'll sort of give you a blueprint for the rest of part 2 of the course. And so, like I mentioned, we're going to be talking about criminal law and civil law at length at the end of part 2. Okay, so sticking with this idea that we need to get some definitions on the table. The first definition that I want to go through and make sure we all have the same understanding of it is the concept of jurisdiction, which is the power or the authority of a court to hear a certain type of case. And this particular power or this particular sort of thing that the court has to deal with can be considered either a doctrinal or an institutional constraint. So we've seen that sometimes the law sort of keeps various courts from hearing certain types of cases, either because, and the reading gets into this as well, but either because the case is not in the geographic area that the court is in, and this deals with geographic jurisdiction, or the case deals with some area of the law that the court is not equipped to deal with. So the second definition that I want to get on the table is the idea of the trial court. And so all cases and all litigants enter all of the court systems through trial courts in America. And these trial courts can be at the federal level or, importantly, they can be at the state level. And so we'll be talking about that distinction as we move forward today. And the purpose of the trial court is to determine questions of fact. So it's to determine what happened in a given case. And these facts come to light through the discovery process. They come to light through the testimony of witnesses. They come to light through trials. So the second form of court that I think it's important that we get on the table is what are called appellate courts. And appellate courts are where appeals of trial court decisions are filed. And there's a distinction here between a mandatory versus a discretionary docket, and this refers to the ability for an appellate court to hear a case. And so the purpose of the appellate court is not to answer questions of law. So for example, in an appeal, unless it's in sort of a special case, new evidence, unless it was seen as being improperly excluded from the original trial, new evidence is never heard by appellate courts. Instead, they're simply determining questions of law. So how have the trial courts applied questions of law? And so when appellate courts answer these questions, they then set a precedent for all future cases that are occurring in courts below them. So the trial courts then have to rely on appellate court decisions. And appellate court decisions have a few components. So the first component is the majority opinion, and the majority opinion reflects the majority outcome and the majority reasoning. So, for example, in the Supreme Court, there are 9 members of the Supreme Court. So, in order to be in the majority, you are required to have the support of at least 5 of the justices. And so, when an appellate court then publicizes their decision on a case, they do so in the form of a majority opinion. The holding aspect of the opinion is the legal doctrine that the majority opinion articulates. And this is usually a really concise statement of the precedent that the ruling has created. So for those of you who are interested in attending law school, after you graduate from TWU, you're going to spend a lot of time briefing cases and identifying the holding in each case. And this is really one of the key components of being an attorney, because it allows you to drill down a majority opinion into what is really essential. The next component of an appellate court opinion is the concurrence. And this doesn't happen all the time, but it does happen sometimes. So sometimes there are justices on an appellate court who agree substantively with the majority opinion decision, but they disagree with the reasoning, the legal reasoning that the majority used to get there. So in this case, their vote would count as part of the majority, but for example, you may have a majority opinion in a Supreme Court case that reflects the legal reasoning of only 3 of the 5 justices who comprise the majority. And in that case, then the remaining 2 justices who are part of the majority would submit concurring opinions either separately or together. And then finally, there is also a dissenting opinion. And in a dissenting opinion, the minority in the court is stating their preferred outcome, as well as the minority's reasoning for the outcome. So in the Supreme Court, this would mean the group of justices who comprise 4 or fewer of the 9 justices, which would, mathematically, of course, make them a minority. And then finally, there's also something called a plurality opinion. And this is an opinion that does not get a majority vote on the court, but sometimes it can become the controlling precedent that lower courts have to abide by under certain circumstances, especially if the plurality opinion would get some combination of 5 votes on the Supreme Court. Okay, so let's talk about how state and federal court systems in the U.S. are organized. So the Supreme Court of the United States is the court of last resort, or also known as the High Court, for both the federal judicial system and state judicial systems. All right, and so we'll talk more about the Texas court system here in a minute, but it's important to note here that it is possible for a case that the Texas Supreme Court, which is the high court for our state judicial system, it is possible for the parties in a Texas Supreme Court decision to further appeal the case. In this case, or when that happens, the case would then go to the United States Supreme Court if they chose to hear it. Underneath the Supreme Court of the United States at the federal level is the U.S. Circuit Court of Appeals. And we'll talk more about these in a minute, but there are 14 circuit courts of appeals in the US. They are geographically contiguous with one another, and every part of the US falls under one of these 14 appellate court jurisdictions. And then underneath the circuit court are United States district courts. So I mentioned the Zeke Elliott case of the Cowboys running back. So the Zeke Elliott case was heard in federal court a few weeks ago. And so it was heard in the Eastern District of Texas. So that is the federal court. So Texas is divided into numerous, or four actually, federal court districts. And the Metroplex, or at least the northern part of the Metroplex, is found in the Eastern District of Texas. And so the main courthouse for the Eastern District of Texas, I'll talk more about this in a second, is in Sherman. So when Zeke Elliott's legal team filed their appeal of his suspension, that is the court that has jurisdiction. So then moving to the state level, there are also state Supreme Courts. I'll get more into the organization of the Texas high courts here in a second. There are also state appeals courts, and then there are state trial courts. And in Texas, the state trial courts can be sort of confusing because we have county level trial courts, and we also have district level trial courts that do not sort of abide by county lines. So for example, Dallas County is comprised of several different county level trial courts, but then also multiple district courts exist within Dallas County. And so Denton, for our purposes, as I mentioned, is located in the Sherman Division of the U.S. District Court for the Eastern District of Texas. It also falls under the Fifth Circuit Court of Appeals, which, as I mentioned in class the other night, is one of the 14 circuit courts. It is based out of New Orleans, Louisiana, and has been for a long time seen as one of the more conservative circuit courts in the country. So if you're looking at what would be one of the more liberal circuit courts, you would have the Ninth District Court, which is headquartered in San Francisco. That's an example of a liberal circuit court. So, and again, it's important to remember that judges at the level of the Fifth Circuit and also judges at the level of the U.S. District Court are appointed by the president and confirmed by the Senate. On the other hand, states have various ways of putting judges in position. In Texas, of course, our judges from the Texas Supreme Court on downward to even sometimes municipal court judges are all elected. Okay, so I think now would be a good time to talk a little bit about federalism, to think about how these two sort of strands of the court system interact with one another. So federalism is the relationship between state and federal court systems of government for our purposes. You could also think about federalism as existing between state legislatures, federal legislatures, governors, president, etc. And federalism sort of generally means the division of power between national and regional governments. Of course, in America, that's the federal government in Washington, D.C., and regional governments that exist at the state level. There's several different kinds of federalism. The first kind is what we call unitary federalism, and here all power is centralized in the national government, and the states themselves have very little in the way of separate powers or concurring powers. You also have a type of federalism that is considered federal federalism, and here power is divided among regional and national governments. This is what we have in the United States, and the Constitution spends a great deal of time in the 10th Amendment and the 8th Amendment, etc., dealing with the relationship and sort of outlining the relationship between the federal and state governments in the U.S. So this is exemplified, of course, by the Supremacy Clause in addition to other parts of the U.S. Constitution. And then finally, you have a confederal form of federalism. And so this is really exemplified by the U.S.'s experience under the Articles of Confederation, which, of course, was the precursor to the U.S. Constitution. So here the power, again, is divided among regional and national governments, but regional power reigns supreme. And so for many reasons that you're probably familiar with through other government classes, the U.S. under the Articles of Confederation did not function very well. And one of the reasons why is because giving the 13 states at the time separate spheres of power, meant for a really confusing legal environment. So back to the way that the federal court system is organized, you can see then here that Texas is in the Fifth Circuit. So Oklahoma, our neighbor to the north, is in the 10th Circuit, and the Fifth Circuit sits in Washington, D.C. And then, of course, the Fifth Circuit rather sits in New Orleans. And of course, Washington, D.C. Has its own Circuit Court of Appeals. All right, so let's talk briefly about the Supreme Court of the U.S., just to make sure we're all on the same page. So the Supreme Court has 9 justices. They are appointed by the president and confirmed by the U.S. Senate for life terms. And as we've talked about, if you think about this in terms of the constrained court versus dynamic court view, this can be either a constraint on the court or it can empower the court, right? And so one of the things that I want you to be able to think about in this class is to think about the ways that the courts are organized and to think about it from both perspectives, right? So how could this be a constraint? And how could it lead the court to being able to act dynamically? So it's a constraint. The appointment power, anyway, is a constraint because, of course, the justices on federal courts, if there is an opening on the court, say somebody retires or somebody dies, they are unable to fill that opening themselves. So they are essentially at the mercy of not only whoever is president at the time, but also the makeup of the U.S. Senate. And so we saw this sort of most tellingly recently when Antonin Scalia passed away rather suddenly in the winter of 2016, the early part of 2016. I think it was either January or February. And when Scalia died, Obama only had 9 or 10 months left in his term as president, his second and final term as president. And so the reasoning that the Senate Republicans gave at the time for not voting on Scalia's replacement is that Obama would be considered a lame duck president, and it should be up to his successor, which of course we know now was Donald Trump, to name Scalia's replacement. And so as a result, the nomination of Merrick Garland, who is a federal appeals court judge, languished for almost the entirety of 2016 in the U.S. Senate. And then, of course, Trump was elected president, and the Republicans continued to control the Senate. And Neil Gorsuch was confirmed to sit on the court in short order. So Congress settled on the number of 9 judges in 1869, and that number has been stable ever since, despite Franklin Roosevelt's effort to pack the court in the 1930s. And so here you can really see the power of the court displayed front and center. As I'm sure you know, in Roosevelt's first few years in office, the federal government democratically controlled Congress, and Democratic President Franklin Roosevelt passed a flurry of New Deal legislation meant to lift the United States out of the Great Depression. But what it also did at the same time was greatly expanded the power and the scope of the national government. And so you had Supreme Court justices who were on the court at the time who were really the only barriers between the passage of these laws and their enaction into law. And so you had the Supreme Court in multiple cases calling New Deal legislation unconstitutional. And Roosevelt at the time, remember, had won in a landslide by 1932. He would go on to be elected again in 1936, 1940, and 1944. And so Roosevelt at the time thought that the Supreme Court was clearly subverting the will of the people. And so his plan was to pack the court and increase the number of justices on the court so that then he could install judges that were friendly to his legislative proposals. This plan, of course, failed. It, in fact, backfired pretty spectacularly and proved to be quite unsuccessful amongst not only judges who were sitting on the Supreme Court at the time, but also the American public. So the Chief Justice of the Supreme Court has no special powers and instead is considered only to be the first among equals. Our current Chief Justice is John Roberts, who came to the Supreme Court from the DC Circuit Court, and he was nominated by President George W. Bush and confirmed in overwhelming fashion by the United States Senate. And John Roberts falls into a typical pattern of Chief Justices in that normally the Chief Justice is installed as a completely new member of the court rather than promoting a current member of the court to Chief Justice when the Chief Justice dies or retires. So in this case, Chief Justice William Rehnquist, who had been nominated by a Republican president, passed away during the Bush administration. And so rather than elevate one of the sitting justices to Chief Justice and then confirming another associate justice, the Bush White House instead decided to nominate John Roberts directly for the position of Chief Justice, which is where he has sat ever since. And John Roberts, if you know anything about the makeup of the Supreme Court, is generally considered a reliable conservative vote. For example, he was part of the minority in Obergefell versus Hodges, which is the Supreme Court case that legalized gay marriage nationwide. However, he has also at times been unafraid to sort of buck Republican orthodoxy, such as when on 2 different occasions he upheld most of Obamacare as constitutional. In fact, he was the 5th and deciding vote in one of those cases, much to the dismay of conservatives. The Supreme Court has a lot of power in the federal court system. Their rulings create binding precedent that all lower courts in both state and federal court systems must follow. So the first part of this, second part of the sentence is really important. So the Supreme Court of the U.S. creates precedent that state courts must follow. The Supreme Court also, of course, has the power of judicial review, which is something that we'll be talking about at the end of the class when we talk about whether the courts are democratic. But judicial review, as I hope all of you know, was the concept that was enshrined in the Supreme Court case Marbury versus Madison, which was heard in 1803, and during the era of John Marshall as the Chief Justice of the Supreme Court. And the Marshall era of the court is really noteworthy. It's probably the most important era of the Supreme Court's history because it was through actions that the court did in cases like Marbury versus Madison, and also Barron versus Baltimore, and a few others that really brought the court up on a level playing field with the other 2 branches of government, the presidency and Congress. Okay, so now let's talk about the structure of the Texas courts briefly. So Texas is in many ways, as I'm sure you're all aware as Texas residents, is a unique place. And Texas likes to think of itself, of course, as being a unique place as well. And one of the things that makes Texas unique is that we have 2 separate high courts. So the first is the Supreme Court of Texas. And just going by the name alone, you would assume that the Supreme Court of Texas is truly supreme and that there is no other court that's on an equal playing field with it. That is actually not the case. So the Supreme Court of Texas is Texas's high court for civil cases, right? So if you think back to the first slide, you remember that civil cases involve disputes between 2 private parties where the state, and here I'm talking about the state, either meaning Texas or the national government, is not involved in the case. Texas, however, also has a second high court called the Court of Criminal Appeals, which has the final jurisdiction in all criminal cases. So if a criminal case is appealed upward after the trial court, then it'll go to a criminal appellate court. I'll get to that in a second. And then it will end up not at the Supreme Court of Texas, but at the Court of Criminal Appeals. Both of these courts sit in the state capital in Austin, and both of them notably are elected. So then below the Supreme Court of Texas and the Court of Criminal Appeals, we have the General Court of Appeals, and there are regional jurisdictions for the Texas Court of Appeals, meaning there is not just one court, but rather they are scattered in a contiguous way throughout the state. And these courts hear immediate appeals from trial courts, and if one of the parties appeals upward after the Court of Appeals makes its ruling on a case, and then depending on whether the case is civil or criminal, it goes to the Supreme Court of Texas or the Court of Criminal Appeals. Below the Court of Appeals at the state level are district courts, and these courts involve original or have original jurisdiction in all civil actions that are over $200. They also have original jurisdiction in felony criminal matters. And the key distinction here is that they do not have original jurisdiction in misdemeanor criminal matters, which is a lower class of offense. We'll talk more about that in a second. Some district courts are specialized. We have criminal or civil district courts. We also have, in big cities, we have district courts that deal with family law, etc. And so there are family law courts that do nothing but family law, so dealing with custody battles, divorce proceedings, adoptions, etc. And those types of courts exist in Dallas and in Houston and in some of the other big cities in the state. And there are 464 total district courts in the state. And so you can see here there's a distinction between district courts and county courts. Texas has only 254 counties in the state, yet there are more district courts than there are counties. And so this is because counties where there are a lot of people, Dallas County, Denton County, Harris County, which is where Houston is, Bexar County, home of San Antonio, El Paso County, Travis County, etc. There will all be multiple district courts within those counties. And then, of course, there are also county courts, and here there are county courts that deal with statutory issues, constitutional issues, probate courts, which involves estate planning, wills, trusts, etc. And so when you're an attorney and you're thinking about where to file a civil proceeding, there are rules that govern this, but sometimes you have your choice between filing in a county court, so Denton County Court, Dallas County Court, or in a district court, which is also part of the state system, as I mentioned, but is not done at the county level. So county court, whenever one of the parties appeals a verdict from the county court, that appeal goes straight to the Court of Appeals. It does not go to the district court. All right, so it's important to think of this as the county courts don't exist underneath the district courts, even though they do in this particular slide, but rather they exist sort of alongside the district courts. And then underneath the county courts are two different types of courts, one that deals with criminal misdemeanors and another that deals with municipal ordinance cases like truancy or curfew cases, or a kid who's not wearing a bike helmet, etc. And in the justice of the peace courts, they deal with small claims and civil actions that deal with less than $10,000. They also deal with criminal misdemeanors. All right, so this is the final slide that has substantive material that I wanted to talk to you guys about today. And it doesn't necessarily apply to what we've just talked about, but it does apply to what we're going to talk about with the October 3rd slides, which is where we discuss how the American courts have evolved over time and how they compare to courts in other countries. And so there is a scholar of judicial politics, taught for many years at Harvard and University of California at Berkeley, named Robert Kagan, who is pretty well known amongst political science scholars and socio-legal scholars as sort of one of the godfathers of thinking about ways in which that we can compare court systems across countries. So again, we'll cover this on October 3rd, but I wanted to at least get it out there for you to think about today. So what we have here is a 2x2 typology. All right, so if you follow along with me, the axes of this typology are on the far left, whether a court process is hierarchical or participatory, all right? And so what this means is you can think of hierarchical as another word for judge-driven, all right? And there's varying levels of this. Of course, there are more than just 4 types of court systems across the world, but what Kagan has done is to organize them along these lines. And so normally courts can be found in one of these 4 boxes. And so if a court is listed as either an expert or a political court or a court that falls under bureaucratic legalism, then it is considered hierarchical. And so there's something that I want to mention right now, and I promise I'll correct this for the next slideshow. But you can see under bureaucratic legalism in the upper right that it says the United States. So that is actually flipped. So the United States falls under adversarial legalism, not bureaucratic legalism. Okay, so bureaucratic legalism is Europe, Japan, etc. The US falls under adversarial legalism. So I'm sorry that this is confusing. And as I mentioned in class, if I had the technological capabilities to pause this, fix it, and then start back up right where we left off, I would do that, but I do not, and we're almost done, so I'm just going to keep going. So, all right, so if we think of a hierarchical court system, think of it as dominated by a judge, not by lawyers, okay? And so participatory court systems are the exact opposite. They are dominated by the parties. And in the United States, the parties involve attorneys, right? So in addition to the litigants in the case, they're represented by counsel. If you're involved in a criminal case in the United States, you are constitutionally required to have a lawyer provided for you, right? So the top hierarchical, judge-driven, at the bottom participatory. So now if you go to the other axis, you can see on the bottom there that the two on the left, expert in political and negotiation and mediation, are considered to be informal. The two on the right, bureaucratic legalism and adversarial legalism, are considered to be formal. And so what we're talking about here are the court's requirement that they are governed by a clearly defined set of rules and precedents. And so let's just go through these boxes one by one so that we can flesh out what this typology actually means. So in the upper left we have, as I mentioned, expert political courts. And you can think of this as like a Soviet-style political court, right? So if you've ever seen, what's the movie called? Bridge of Spies. Have you ever seen Bridge of Spies? So if you've seen that movie, you know that there's a U-2 spy plane pilot in the U.S. named Gary Powers who was shot down over the Soviet Union in the 1960s. And he survived his plane being shot down, but was sent before a Soviet-style court to be punished by the state for spying on the Soviets on behalf of the Americans. And so in a Soviet-style state, it's very hierarchical. In a Soviet-style court, it's very hierarchical, meaning it's dominated by a judge, but it also doesn't rely very much on precedent. So judges are not bound by precedent when putting forth decisions. So they could say, in Powers' case, you're exiled to a labor camp for 7 years. In somebody else's case, you're sentenced to death. In somebody else's case, you're sentenced to house arrest for 20 years, right? So it's really at the discretion of the judge what the punishment is and how the quote-unquote trial proceeds. So now if we go down below that, we're in an entirely different style of dispute resolution. And here, it's called negotiation and mediation. And so probably you've heard of mediators in the American legal system, and these are not judges, and they are not lawyers who are representing one of the parties in the case. Normally they are lawyers, but they're seen as neutral. And the idea here is to resolve a dispute before a case ever reaches the court system and takes up time in the court system. And oftentimes you'll see courts require that parties go to mediation at some point during a trial or before a trial, but after a lawsuit has been filed, with the hope that the parties could reach a resolution before the court has to spend a lot of resources. And so this is sort of an interesting realm of the law because it is very informal, just like a Soviet-style political court, but it's not at all dominated by a judge. Instead, it is dominated by a person who sits somewhat in this, triadic relationship, but the parties are not required to listen to the mediator. The mediator is simply there to hopefully facilitate an agreement between the parties that is somewhat mutually satisfactory. So, all right. So we have the expert political courts, we have the negotiation mediation courts, but it's really the two court types on the far right that I'm interested in. So again, bureaucratic legalism, not found in the United States for the most part, but found in Europe, Japan, New Zealand, Australia, Germany, etc. So these are justice systems that are hierarchical, but are also formal. right? So in this case, they are bound by precedent. So it's not like a judge can just like willy-nilly assign you to punishment in a labor camp for 10 years. Instead, they are bound by precedent, but they are also not dominated by lawyers. Instead, they're dominated by judges. So it's judges who discover, or who rather lead the discovery process. So it's the judge that decides what the facts are. It's the judge that decides which facts are admissible. It's the judges or a panel of judges that often goes on the hunt for information. So lawyers do play a role in a bureaucratic legalism court, but not nearly as big of a role as they play in the US. So in the US, which is found in the bottom right box under adversarial legalism, lawyers play an enormous role. In this particular style of court. So I'm going to go here and just fix this real quick. So stick with me. I'd hate for you to still be confused by this, so just wait for it here. You're seeing how the sausage is made. This is very exciting for you, I'm sure. Okay, so now it's fixed. So bureaucratic legalism, Europe, Japan, etc., adversarial legalism, United States. So here, courts are bound by precedent, but the way in which they function and the driver of the action in this style of court system is not a judge, but is rather a lawyer. And this is a really, really important distinction, and it's a distinction that we're going to explore at length in our next class. All right, so for now, just make sure that you have a good sense of what bureaucratic legalism and adversarial legalism are. So again, bureaucratic legalism is formal. It's governed by precedent. It is also dominated by a judge. Adversarial legalism, also formal, also governed by precedent, but not dominated by attorneys, instead not dominated by a judge, but instead dominated by attorneys. And so these axes, just to get them out there, informal to formal are the extent to which decisions are made according to pre-existing rules and procedures, and hierarchical and participatory is the extent to which legal processes are dominated by government officials, i.e. judges. Okay, so to sum up, some questions to think about. Does the organization and structure of the court system in the US, does it constrain or empower the court system to act politically? And this is, of course, Gerald Rosenberg's question in the CCV versus DCV debate. And you can see how it would go both ways, right? So, for example, the appointment process appears to be a constraint on the court. They can't even fill their own vacancies. But at the same time, appointing a judge for life insulates them from political pressure and allows them, in theory at least, to focus on questions of law, not of politics. Secondly, you can think about the organization of the courts vis-a-vis the states and this idea of federalism. So on the one hand, you might say that the way that the courts are organized in sort of overlapping spheres of authority is confusing and actually limits judicial power and judicial coercion. And that may be the case because these courts are all sort of separate centers of power, and they often issue contradictory or sort of overlapping rulings. But on the other hand, if you think about judicial power and coercion not as national in scope, but rather these courts having the ability to sort of issue their own rulings, take matters into their own hands, then you can see that the organization in terms of federalism in the courts could actually be an empowering factor. Secondly, how does the selection of judges in Texas either prop up or undermine the logic of the triad? So as I mentioned on the slide where we talked about the Texas court system, judges in Texas are not appointed by the governor. They are instead elected by the people. So the Supreme Court of Texas and the Court of Criminal Appeals, the two high courts, those are statewide offices that everybody in the state, when a slot on that court is up for re-election, everybody in the state can vote for those positions. So district courts and county level courts, of course, you can only vote for judges if you either live in the county or you live in the district. And so it's interesting to think about. I mean, there are pluses and minuses of the election of judges. I sort of personally fall on the side that the election of judges is not a very good idea. But I can see the logic in the other side's argument, which is this, that judges should be accountable to the people. And one of the ways in which the people can hold judges accountable is through their election. And so if a judge is misbehaving or if a judge is making rulings that sort of fall outside the legal or political culture of a state, then state voters should have the ability to exercise the right to remove that judge from office. And so you can think of this logic of the triad. If you remember back at the beginning of class, we talked about how sometimes the logic of the triad rests on the perceived neutrality of the judge, and sometimes the logic of the triad rests on the legitimacy of their decisions. So I don't think it's too far off the mark to say that in a system where judges are appointed, not elected, their neutrality is better protected, right? Because they don't have to seek money in order to run for election, and they can stay pretty insulated from the political process. On the other hand, when a judge is appointed, not elected, I think clearly their link with the people is not nearly as strong as it is when they're elected. So this idea that a judicial opinion can be sort of legitimized through the popular legitimacy of the opinion. In a case where a judge is appointed, I think that that's much harder to do. On the other hand, you can't argue judicial legitimacy in a system where judges are elected because, as the argument goes, if the people found the opinion to be illegitimate, then they would, of course, punish the judge by not reelecting them. So that's the end of the slideshow for today. We are going to get much more into the Kagan material for the 6th week of class, which is the 2nd week of part 2, and that material will hopefully be posted next week in advance of its October 3rd date. And like I mentioned, or I may not have mentioned this, I can't remember, but you will have discussion board questions not due over this material that we just covered, but instead this material plus the material for October 3rd. So make sure that you check Blackboard for the discussion due date. And if you have any questions on that, please feel free to, of course, email me or stop by office hours on Monday or Wednesday, which are 12:30 to 2:30 p.m. And if you can't make those, I'd be happy to talk to you via email or over the phone. All right, thanks so much.